Salutations to all our future judges. In this video, we are going to see the Code of Civil Procedure 1908, Part 15, Sections 61 to 73. If you have not seen the earlier part, that is Part 14, I am providing the link in the iCard. You can click that and you can watch the 14th part of this series. If you want to see the entire playlist, I am providing the link in the description. You can click that link and see the entire playlist. Let us try to understand section 61. Partial exemption of agricultural produce. So the state government can pass a special order and they can publish it in the official gazette saying that a particular portion of an agricultural produce cannot be attached or any class of agricultural produce cannot be attached. The reason for this is the government may feel that till the next harvest the agriculturalist, his family has to survive. So the government will think the safety of the agriculturalist or the future of the agriculturalist. They will ensure that the judgment debtor who is agriculturalist and his family should survive till the next harvest. So to that extent, the government may say that a particular portion of agriculture produce cannot be attached or any particular class of agriculture produce cannot be attached. This will be exempted from liability to attachment or sale in execution of a decree. The main purpose is to support the farmers till the next harvest. Let us move to section 62. Seizure of property in dwelling house. Let us move to subsection 1 of section 62. Generally, for seizure of any movable property which is inside a dwelling house, a person who is executing the process cannot enter into that house after sunset and before sunrise. This can be asked as a question in the preliminary examination. They can ask one word question from this particular section. They can ask the section number also. So you need to be prepared. Let us move to the next subsection, which is 62 subsection 2. Now let us imagine a scenario. There is a person by name A. He is the judgment debtor. He has to pay the money. Now the person who is coming to execute the process from the court is calling that person to hand over the property. So what this person does is he takes that mobile property along with him. He goes into this house and he closes the door. Then he is not permitting the person who has come to execute the process to enter into the house. So this person can break open the house. That is the first point. And in case this person has obtained or duly gained access to the dwelling house by breaking open the door, he can also break open the door of any room where he thinks that property is available. Generally, it used to be a movable property. So, a person who is executing the process can break open the door. That is the one point we need to understand. Let us move to subsection 3, which is 62 subsection 3. This particular subsection is quite a different scenario. Imagine a judgment debtor is sitting in a house along with his wife. And that wife, as per the customs, is not permitted to appear in the public. So, the person who is going to execute the process, he is knowing that the wife of the judgment debtor is sitting inside the house and that she is not permitted to appear in the public. So, what he will do is, he will give a notice to that lady. He will say to that lady that you can withdraw from this place. And after giving reasonable time for her to withdraw, he can enter the room and seize the property. But he should take proper precaution inconsistent with the provisions, because there should not be a clandestine removal. What this clandestine actually means? Clandestine means doing something in a secret or in an illegal manner or not permitted manner. So this person who is going for execution should not do something in an illegal manner or in a secret manner. Let us move to section 63. Property attached in execution of decrees of several courts. Once a question was asked from this particular subsection 63 subsection 1. The question was whether a property which is already in attachment can be removed by an equivalent court. Something of a similar nature, a question was asked. So the first important point which you need to understand in this particular section is that property should not be in the custody of any court. This is the most important point. First point is that property should not be in custody of any court. If it is in custody of any court, this particular section will not apply. That is the first point you need to understand. The next important point is that property should be under attachment in execution of decrees. This is the second point. And the third point is that the property should be in attachment in more courts than one. If it is only in one court, then there is no confusion. If it is under attachment in more than one courts, there comes the confusion. Then which court will have the power? Imagine there are two courts, court A and court B. These two courts have attached the same property. Then which court will sell it or implement the execution? So this is a question which needs to be answered. So in this case, the first question which will be seen is which court is of a higher grade. For example, A court is say a principal district judge, and imagine the B court is a district municipal court. So in that case, this A court, which is the principal district judge court, will decide. It will realize such property, it will receive and realize, that is, it will sell the property, and it will ensure whether there are any objections to the attachment. Then accordingly it will decide. That is the first point in this. And in case if there is no difference in grade, say A court is also a district municipal court, B court is also a district municipal court, then the first court which attach the property will have the right. The second subsection under section 63, nothing in this section shall be deemed to invalidate any proceeding taken by a court executing one of such decrees. Imagine court A is trying to execute such decree. It is doing some proceedings with respect to that. Now the question is, A court has also attached, B court has also attached the same property. So the judgment debtor is putting a claim saying that, see, already B court has attached, so your attachment or your proceeding will get invalid. That cannot be done. It will still be valid. They have given explanation for this particular subsection 2, the proceeding taken by a court, what it actually means. So if that particular court gives an order to a decree holder who has purchased the property at a sale held in the execution of a decree. Imagine I am the decree holder. I got or obtained an order in my favor against the judgment debtor. He has to pay me money. He did not pay the money. So I obtained an order saying that that property can be sold to me or to any other person who pays that money. So I go to the auction. I purchase the property. I am the decree holder. So the court says, yes, he has paid the money, so let him take the property. So he is adjusting the amount which is payable by the judgment debtor, and he purchases the property. Some additional amount he has to pay, he has paid that amount also. And set off is also there. Set off means if somebody has to pay me some money, he has not paid, I am adjusting it towards the property which I get from him. Generally that is called a set off in a normal man's perspective. So in this case, if that particular set off is being done towards the purchase price payable by him, imagine the property value is 10 lakhs. The amount payable to the decree holder, that is to me, is also 10 lakhs. So for this 10 lakhs, that property is being auctioned. I say, like, I'm ready to set off my amount, let that property given to me. So I take the property. So in these cases, proceedings taken by a court, that term will not include these kind of orders. Let us move to section 64. Private alienation of property after attachment to be void. Imagine there are two persons, person A and person B. Person A is the decree holder and person B is the judgment debtor. Now, person A files a execution petition and obtains an order for attachment. So the attachment has been made now. So now this B, who is the judgment debtor, tries to transfer the property to someone else or tries to transfer the interest over the property. So in that case, that kind of transfer or delivery of the property is absolutely invalid. That is the subsection 1 under section 64. Let us move to subsection 2 under section 64. If this particular transfer happened before the attachment, then that kind of transfer or delivery of property is valid. The important condition under this particular section is that that particular contract should have been entered into and registered before the attachment. The point is, they might ask a question whether such a contract should be registered. The answer is yes. And let us move to the explanation. Particularly for this section, claims enforceable under an attachment includes claims for the rateable distribution of assets. For example, imagine there are three decree holders who should divide the property between themselves or divide the proceeds of the property between themselves. In that case, if there should be a rateable distribution, whether that will get included, the answer is yes, that will also get included. Next is sale, section 65. Purchaser's title. Let us move to section 65. Purchaser's title. If a immovable property is sold in execution of a decree and that sale also becomes absolute, when this particular property will vest in the purchaser, the time frame, the answer is when the property is sold. Actually, what they do is when the sale becomes absolute, the property will be given to that person. So when that particular process takes place, that is when the property is actually sold, that is the time when the purchaser gets the right. Let us move to section 67. 66 is already repealed. Hence we will move to section 67. Power for state government to make rules as to sales of land in execution of decrees for payment of money. So there may be certain areas in a state where the determination of such interest can be uncertain or undetermined, and practically it might be impossible to fix their value. In these areas, by a special notification in the official gazette, the state government can make rules imposing certain conditions. That is the subsection 1 under section 67. Now let us move to 67 subsection 2. When this particular code, that is civil procedure code, came into operation in any local area, from that day onwards, the new notification will apply. Let me try to explain this with an example. Today, the date is say 1/1/2023. So the civil procedure code is coming into play or coming into operation on 1/1/2023. This is not the exact date. I am trying to make you understand it. There were certain special rules prior to this particular date. That is before 1/1/2023. There were certain rules which was being followed. So now the state government will give a notification in official gazette saying that these rules are altered or changed or modified or removed or taken as such. So the state government has got the power to amend all these things. Let us move to 67 subsection 3. If there is a rule made under this particular section, it shall be laid before the state legislature as soon as may be after it is made. Let us move to the next aspect, delegation to collector of power. Section 68 to 72 is already repealed. So let us move to the next section, distribution of assets, section 73. This particular section is very important section. Many times they have asked questions in preliminary exam as well as in mains exam in various states. Proceeds of execution sale to be ratably distributed among decree holders. Let us try to understand this particular section by way of an example. There is a person A who is the judgment debtor. He has to pay money to 7 members and let them call them as number 1, number 2, number 3, number 4, number 5, number 6 and number 7. So totally 7 members he has to pay the money. That is the point. So what happens is all these 7 people apply to the court saying that A has to pay us money. He has not paid our money. So let his property be sold and the proceeds may be given to us. So in that case, after deducting the cost of realization, for auctioning the property, there might be some expenses. After deducting all those costs of realization, it shall be distributed among the 7 members, subject to the following conditions, subject to the following provisos. Let us move to point A. Imagine this A, who is the judgment debtor, he has mortgaged the property to one Mr. B. So that person has obtained the money for the mortgage. Mortgage money he has obtained back or he has received back by way of sale. In addition to that, some minor interest he might have received. So after this, if there is any surplus from the sale of property, he cannot go and claim that money. He can claim his mortgage money. That is absolutely fine. But he cannot go and ask the surplus money arising from such sale. Let us move to the next point, which is point B. In this point, what they will do is there might be a mortgage. That is, a encumbrance has been created. So the court will try to sell the property free from the mortgage or charge and tell to the mortgagee, sir, he has to give you money, we understand. We'll sell this property without your mortgage. We'll obtain the money, then we'll pay the same interest what he had on the property. So with his permission, the court will do this. This is a practical thing which we need to know. Let us move to the next point, which is point C. Where any movable property is sold in execution of a decree ordering its sale for the discharge of an encumbrance thereon. Imagine there is an encumbrance in a property. To realize this encumbrance, they sell the property in discharge of the encumbrance. First, the defraying expenses of the sale. That is, when I'm trying to sell a property, there may be some expenses. So that expenses will be deducted first from the amount I get by the sale. Second is the discharging amount due under the decree. As per the decree, how much amount is to be paid, that amount will be deducted. Thirdly, interest and principal money on subsequent encumbrances. Imagine I am going to the court and obtaining a decree. There is another person who is also entitled for the money by sale of the property. That person will come next to me. First, I am the decree holder. I'll get my money first. Then it will be, then the balance amount, whatever be the balance amount, it will be paid to the other person. The fourth point is, it will be ratably distributed among the holders of decree for the payment of money. The important condition is that they should have made the application prior to the sale of the property. They should have applied to the court saying that if you sell the property, pay us money. So in that case, if they have not obtained satisfaction, that is the next important point. So in all these cases, it will be distributed proportionately. In all these cases, it will be distributed ratably among the persons who are entitled to get the money. Let us move to subsection 2 under section 73. If there is a particular person who obtains a property or who's distributed the money from the proceeds of the sale, but he is not entitled to receive it. So in that case, the person entitled may compel him to refund the assets. Imagine there are 7 members. 7 members should get the money. So now the 8th member is coming inside. He is being paid, though he is not entitled. So because of this, the 7th member could not get the money. So the 7th member will sue the 8th member saying that you refund the assets. I need to get my share. Let us move to subsection 3. This entire section will not affect the rights of the government. Government will not get affected by this section. So simply it will not apply to the government. If you like the video, please do press the thumbs up button and leave your comments in the comment section. And do subscribe the channel and also share the channel with your friends. Let us join hands together and contribute for a learned society. Thank you.